In today's video, we're talking about a question that comes up a fair amount during our consultations, which is, do you mean I'm going to have to give up half of everything I own? I'm Jenny Bradley. I'm an attorney, and I'm the founder of Triangle Smart Divorce here in Cary, North Carolina. I'm going to explain briefly how the equitable distribution process works in North Carolina. This is based upon my knowledge and my legal team's knowledge of handling thousands of cases involving equitable distribution, also known as property division. So basically, you need to know that there are 4 types of property in North Carolina. There's separate property, there's marital property, there's divisible property, and then there is mixed property / hybrid property. Separate property. Think of anything you owned before you got married. Your high school yearbooks, maybe a car, those types of things. Marital property. Think of everything that you acquire between when you get married and when you separate. Presumably marital property, unless it was a gift from someone other than your spouse or it's some sort of inheritance that you've received. Those types of things would be separate property. So separate property is not only what you had before you get married, but it's also inheritance received or gifts received by third parties during your marriage. Divisible property. That is a type of property that was created in 1995 to deal with the period of time between when you separate and when you actually divide your property. It's meant to deal with things that occur that are just matters of timing or market changes. Market changes are things like the house market failed and collapsed on us somewhat in 2008, and it started to rebound and we came out of that recession. We may or may not see that again now here in 2020 with COVID-19, but those are the market changes we're talking about. How the stock market is going up and down, how the housing market is going up and down. That's nothing that anyone in the marriage is having anything to do with. Those are outside influences and market changes. Also, divisible property was put in place to deal with things that might happen after separation, but really should be marital property, such as you separated in January 2020, you file your taxes and you get a refund. Well, that refund is based upon 2019's tax pay-in, labor, wages, everything that was done during the marriage, and just by virtue of the nature of timing of when we file tax returns and we get refunds, did that come in after you separated? Those types of things would be captured as divisible property. And hybrid or mixed property. That's a piece of property that has characteristics of both. A common one we see is separation happens, and then we start looking at the folks' retirement account, and we realize that they have worked for this company both before they were married and after they were married. And so we have to figure out how much of this property is separate, how much of this property is marital, because it's only the marital part that is subject to division. And in most cases, actually, that has a component of separate property after separation because the person continues to contribute to it after separation. Could also have an element of divisible property to it because the retirement account goes up and goes down based upon changes in the stock market. So a retirement account is an example that could cover all of the types of property, and you need someone to help you tease those out, and sometimes we have to employ accountants and CPAs, and even at times, numerologist probably isn't the right word, but financial analyst to help us determine what that separate property, what was in that retirement account at date of marriage, and what it would have grown to if it had been invested the exact same way that the account was actually invested. And so there's lots of moving parts there when we deal with hybrid and mixed property. Okay, then you need to know that the presumption in North Carolina is a 50-50 division of marital property and divisible property. That doesn't mean that you take a cleaver and you chop the marital estate in half or anything like that. You don't have to sell off everything and split the proceeds, but you have to do balancing. If one person is keeping the house, another person might need to keep more of the money in the bank. If one person is keeping this car and it's underwater, then the other person might keep that debt to keep debts at an equal situation. And so there is a presumptive division of 50-50 and a presumption that equal is equitable under our statutes. sometimes equal is not equitable, and there are a list of many factors in Chapter 50-20 of the North Carolina General Statutes for reasons why 50-50 might not be equitable. Those reasons are based upon economics, such as one person brought a lot of separate property to the marriage, but then they contributed it to a marital home, or they paid off the other spouse's debt. That money's not there anymore to get it back in the last instance, but the court would note that, hey, you contributed your separate estate to help improve the financial position of your spouse. Checkbox for you, maybe you should get more than 50%. Also, some situations are somebody committed waste. By way of example, I had a case one time where the person went through the house and took out all of the knobs and the pulls and the light fixtures and the light plates and the wall socket plates and everything like that. And the court found, hey, you damaged this house and you caused it to be sold at a lesser number than it could have been. So I'm going to penalize you under the factors and say you committed waste to the marital estate, so you shouldn't get half of the proceeds in that situation. So it does happen, but it's somewhat rare for a court to do something other than 50-50. I'll say that myself and my legal team, that we have been practicing combined more than 50 years of family law, and we can probably count collectively on two sets of our hands how many court cases have done anything radically different from 50-50. I mean, sure, there have been some 52-48s, some 51-49s, but we're talking 60-40. I can't even count that on one hand in my actual cases, and I've been doing family law for 21 years. It just doesn't happen that often. And so you should know that when you negotiate with your spouse, it's fine to ask for more than 50-50, and if you can get it, great. You may have gotten a better result than on your best day you could ever get in front of any family court judge in Wake County, North Carolina. So I'm not saying they're ignoring the law. I'm just saying that there are a lot of factors under that statute, and sometimes they knock each other out. Again, I had a situation, gentleman contributed his separate property to a marital asset, but wife also worked in that company for free, meaning no salary, and thus didn't pay into the Social Security system, and the judge found, hey, those two factors knocked each other out. So be mindful of those things when you think, I did all the work and I should get 100% of everything. That's just not how it works when you go to court. And the last thing you should know about how equitable distribution works is that the court tries really hard to return your separate property. So if you had money in the retirement account before you got married, as I referenced before, the court's going to try really hard to segregate that out and say, hey, you get that. If you put on appropriate evidence to be able to show the judge what that amount was. Also, if you can show, hey, this is a table and it was given to me by my grandmother during our marriage, the judge is going to try their best to give that table back to you under the theory that, yes, it is separate property and it was given to you by a family member. Again, the more documentation you have, pictures you have of you going to get it from grandma's house, grandma being able to testify and say, yes, I meant to give that to Susie and not to Susie and Steve, those types of things are going to be really, really helpful. Not 100% necessary, but super helpful to the court for the court to determine, was this a gift to you or was it a gift to the marriage from someone? Same way with inheritance. Best if the inheritance says to Susie, not to Susie and Steve, because then it could be deemed to be an inheritance to the spouses together and thus be marital property. So, equitable distribution in a nutshell. That's less than 10 minutes of it. They teach classes upon classes of this. I go to seminars that spend days talking about equitable distribution. Don't think it's as simple as I've made it here. This is a very high level, 10,000 foot view of it. But I wanted to go ahead and allay those concerns of people who say, am I going to have to give up half of everything I own? Well, yeah, that's probably true. But remember, the other side's going to have to give up half of everything they own too, except for separate property. So know that as you are thinking about things. If you have more questions about ED or if you need help with ED, please call our office, make a consult. This is a dangerous area to be trying to handle on your own. Thank you for watching.